Good morning, all. This is Dr. Saurabh Bajpai, Associate Professor, School of Management, Babu Banarsi Das University, Lucknow. Today, my subject is Business Law. My contents are Introduction to Business Law, Indian Contract Act 1872. So, let us proceed. So, law includes all those rules and regulations which regulate our relationship with other individuals and state. This is the basic definition of law. Law means set of rules. It may be defined as the rule of conduct recognized and enforced by the state to control and regulate the conduct of people. There are several branches of law, such as international law, constitutional law, criminal law, civil law, etc. Because ignorance of law is no excuse. For example, if X is caught traveling in a train without ticket, cannot plead that he was not aware of the rules regarding the purchase of ticket, and therefore he may be excused. For another example, if Y is caught driving a scooter without driving license, he cannot plead that he was not aware of the traffic rules regarding the obtaining of driving license, and therefore he may be excused. But this is not so the case, because law is for everyone to hold the conduct of people. So what is business law? Business laws are those laws which regulate the conduct of business. Like general law is to conduct the behavior of people, business law is to regulate the conduct of business. The law of contract is regulated by Indian Contract Act 1872. In simple words, the purpose of law of contract is to ensure the realization of reasonable expectations of the parties who enter into the contract. Because in business, there must be two parties who want to enter into a contract. So there must be some rules and regulations to regulate these parties. There is a definition. According to Sir William Anson, the law of contract is intended to ensure that what a man has been led to expect shall come to pass, and that has been promised to him to perform. The business law is basically work on two things: jus in rem and jus in personam. Jus in rem means right against the world at large. Just in personam means the right against particular persons. Definition of contract. Section 2H of Indian Contract Act 1872 defines a contract as an agreement enforceable by law. So a contract is an agreement made between two or more parties which the law will enforce. An agreement enforceable by law is a contract. So what is contract? Contract is agreement plus enforceability. Agreement is equal to offer plus acceptance. An agreement is defined as every promise and set of promises forming consideration for each other. So now we begin with the definition of promise. A promise is defined thus: when the person to whom the proposal is made signifies his assent there to the proposal is said to be accepted. Actually, there are two parties in any contract. So one have to make something for the things they want to complete, and the other parties have to accept it. And this acceptance and offer will make a promise. A proposal, when accepted, becomes a promise according to section 2B. And an agreement is an accepted proposal. Mind you, there are two parties who agreed on something, an offer and proposal. Next thing is consensus ad idem. Consensus ad idem means same thing on the same sense. The essence of the agreement is meeting of the mind of the parties actually. They have to agree on the same thing and in same sense. For example, If A owns two horses named Rajans and Hansraj, A is selling horse Rajans to B. B thinks he is purchasing Hansraj. There is no conscious DSM consequently in the contract because they are not on the same thing in same sense. What is obligation? An agreement to become a contract must give rise to some legal obligations or duty. Once a promise is made, there must be a obligation on both the parties. An obligation is a legal tie which imposes upon a definite person or persons the necessity of doing or abstaining from doing a definite act or act. They have to do something or they don't have to do something. That will be the promise between the two parties. For example, E agrees to sell his car to B for rupees 1 lakh. The agreement gives rise to an obligation of the party A and party B that A have to pay 1 lakh rupees and B have to give his car to A. So there is an obligation on both the parties. An agreement which gives rights to social obligation is not a contract. Any social rights actually is not a contract. An agreement may be a social agreement or legal agreement. A invites B to a dinner, B accepts the dinner. This is a social agreement and this does not need any agreement or obligation. All contracts are agreements, but all agreements are not necessary contracts. This is a very important fact because in agreement, there may be missing some definite or essential elements of contract. So what are the essential elements of contract? Essential elements of valid contract are section 2H and section 10. There must be offer and acceptance, intention to create legal relationship, lawful consideration, capacities of parties, and free and genuine consent. Lawful object, agreement not declare void, certainty and possibility of performance, legal formalities. So one by one, we will discuss all of these. So first thing, which is most important is offer and acceptance. There must be two parties to an agreement. That is one party making the offer and the other accepting it. The terms of the offer must be definite and the acceptance of offer must be absolute and unconditional. That acceptance must also be according to the mode prescribed between both the parties. Second is essential to create legal contract. When two parties enter into an agreement, their intention must be to create legal relationship between them. If there is no intention on the part of the parties, there is no contract between them. Example, a husband promised his wife a household allowance of 30 pounds every month. Later, the party separated and the husband failed to pay the amount. The wife sued for the allowance because there was a contract between both the parties. Lawful consideration is very important. An agreement to be enforceable by law must be supported by consideration. If there is no consideration, there is no agreement, sorry, there is no contract between the parties. Consideration actually means something which both the parties get. It may be a past, present, or future, but must be real and lawful. Essentials of a valid contract have fourth point, capacity of parties or competency of the parties. Actually, there are certain things also in between the contract which is very essential to complete the contract. Like a person must not be minor, that is he must attain the age of majority. He must be of sound mind, that is he may not be a fool or a person with absent mind. He must be not disqualified by the contract of law. Free and genuine consent. Every contract must be free and genuine. That is, which means the consent of the parties must be free from any outside force according to section 14. The contract must be on lawful object, which means that it must not be legal, must not be immoral or opposed any public policy. The agreement between both the parties must not be declared void by the law. According to Indian Contract Act, they must not be void by the law. certainty and possibility of performance. The agreement must be certain and vague or uh, indefinite. Section 29, according to Section 29, it is vague and it is not possible to ascertain. That is, it cannot be enforced. For example, A agrees to sell B 100 tons of oil, which cannot be made by A. So this contract must not be performed. Legal formalities. Ninth point is legal formalities. A contract must be made by words spoken or written. As regards at the legal effect, there is no difference between a contract writing and a contract made by words of a mouth. It is, however, in the interest of the parties that a contract should be in writing, because without in writing, it is not enforceable by law. In some other cases, a contract, besides being a written one, has to be registered. But it may be different from the situation. Essential condition of the contract is it must be written and enforceable by the law. So these are the basic, most important features of essential important features of a contract. Thank you. Thank you all.